Okay, call to order for Alpine Planning and Zoning Commission meeting, July 28th. It is 5:30 PM. City Secretary, do we have a quorum?
Yes, we do.
We do have a quorum. City Secretary, was the notice posted of the meeting in time?
Yes, the notice of this meeting was posted by 5 PM on July 22nd, 2025.
All right, thank you. We'll start with public comments. Each person in attendance who desires to speak to the board on an agenda item shall speak during this section. You will each get 3 minutes. There will be no questions from the board during this section. Public comments may be made regarding agenda items only. Attendees must be physically present. Public comments are limited to 3 minutes, and like I said, no questions. Are there any public comments? When you do want to make a public comment, please step up. You have a microphone at the podium. State your name and where in the city you reside. So public comments? Seeing none, there are no public comments. We will move on to public. I can't hear you.
In response to particular, if I have a protest.
Well, we got the public hearings on each one of these sections here. You can wait and do that then too. We will move on to the public hearings. The public may address each item listed in the section. Comments made during this section are limited to that topic. Attendees must be physically present. Usually you get 3 minutes per person. Once again, here we can ask questions if we need to. Unused time may be yielded. So we will move on to A, public hearing. Do you want to read that one?
Sure. Public hearing A is public hearing to obtain citizen views and comments regarding variance 2025-08-01. A variance application that would allow the applicants Alvaro Martinez and Elizabeth Martinez to establish a variance to the setback requirements of the subject property. The acceptable setback is typically 25 feet from a structure to the property line. This variance would allow the subject property 0 feet of setback from the structure to the property line, which typically does not meet the requirements for a residential lot under the city's code. The non-conforming subject in question was established prior to adoption of the city's code and setback requirements. The subject property is located at 502 South 5th Street and is legally described as Block 1, Lots 1 through 4, Ferguson addition to the city of Alpine, Brewster County, Texas. The property owner of record is Jaques Alberto deceased, care of Alvaro Martinez. The property ID of the subject property is 10377. The current zoning classification of the property is R3 Apartment District. If the variance is approved, the zoning classification of the subject property will be R3 Apartment District.
Okay, is the applicant present or on TV?
I'm on Zoom. My wife is the one that actually filed the application and she's on her way. She's stuck in traffic. She should be here any minute.
Okay,
If they want to make a comment.
we'll get some other comments first and then you can make your comment.
Thank you.
Anybody else want to make any comment on this application? Anybody online?
Now would be the time if it's going to be concerning this agenda item.
So there are no public comments on this item?
I do have a public comment, if you can hear me.
Okay, yeah, I can hear you. Go ahead.
Great.
Identify yourself and state where your concern is.
Sure, great. My name is Kara Coates, and I'm a property owner at 508 South 5th Street. On behalf of 3 neighboring property owners, we do object to the variance request for 3 reasons. First, there's insufficient information presented upon which to determine the impact of the request on the neighborhood. Second, the public notice indicates there will be a 0-foot setback from the property line, which is not acceptable to the property neighbors, but that doesn't seem accurate. Third, the application does not fully reflect applicant's verbal description of the proposed improvements. Unfortunately, over the last several years, applicant has allowed tenants to accumulate junk, including unregistered cars, on the property, and the property is an eyesore. Therefore, if a variance is granted to allow a second rental dwelling on the property, neighbors worry it will make the current inattentive landlord situation worse. While we generally support efforts to fix up the property as applicant has verbally described, meaning a single-family, one-story home in the current footprint for use by the owner, not as a rental, that's acceptable to the neighbors, but this is not fully reflected in the application. Therefore, we request that the applicant resubmit with the following information. Number one, specifically identify the portion of the ordinance relating to setbacks for which a variance is requested, as opposed to just listing the entire zoning ordinance. Number two, include a drawing that clearly identifies which building the variance is requested for, and a map that makes it clear what property line or lines the variance is requested from. As I mentioned earlier, the public notice states that it's a 0-foot setback, and I think from the road, but the property owner told me verbally that it's 13.5 feet from the road, so it's a bit confusing. It's hard to follow. Also, the building, which I believe is at issue, is very close to the property line to the south, and I don't know if that also needs a variance. Number three, the application should make it clear that the building footprint will not be expanded and that the variance request is limited to a single-family, one-story dwelling. Number four, applicant has told us over the phone and via text that the building would be used by family and not as a rental. The application should make this limitation clear and describe how that would be enforced. Lastly, the application should include a site plan of the full property showing where parking would be. Parking demands to accommodate a new residential dwelling on Fifth Street is a concern for the neighbors. The neighbors have shared these concerns with the applicants in advance of submitting this objection to the Planning Commission, and we appreciate the opportunity to provide comments.
All right, thank you so much. Anybody else? Any comments?
My wife is not here. I'd like to know who the neighbors are because I spoke to Mr. Mendoza and I spoke to Ms. Espinosa. They didn't express any objections to me.
Okay, so you're
I-
addressing the board right now.
I'm sorry.
Any-
And I don't know if you can hear me. I am here and I have been here since the meeting started. This is Elizabeth Martinez. Are you aware that I'm on as well? I'm on in my car, but I'm on. Yeah.
We can see you on, yes.
Okay, great. I don't know. I guess my husband couldn't tell that I was or not, but I'm still driving. As far as her, Kara's concerns, all those were addressed in my application. Everything about the variance, she and I went over it. She thinks that her property is very close to, or her property line is very close to this, to our property, and it is not. She's looking at a plat that is an internet plat, and I don't believe she's seen the actual survey. And if she is really concerned about how close it is to her property, then she needs to go ahead and do a survey for her property so that she can have her peace of mind that it is not close to the property. The other concerns that she has, Kara has had my phone number for all these years. Not once has she said, hey, your tenant is doing this or that or the other. I'm not liking how it's looking. Not once until we asked to remodel the little shed. She knows exactly which one it is. And the other neighbors have zero problem with this. So including them in our neighbor things, no, I'm sorry, no, Kara. The neighbors did not say that at all. And had they been really concerned about this, they would be online as well.
Okay,
Because
Ms.
my husband
Martinez,
went
Ms.
and
Martinez,
Yes.
you are addressing the board right now, not Kara.
Okay, well, those are her concerns. My biggest thing is that she never once called me to say, hey, the neighbors are doing this, or the neighbors are making the neighborhood look bad, or whatever. Not once. Was that a concern of hers until I requested the variance?
Okay, the
Yeah.
board will address you and have questions for you when we get to the discussion period.
Okay.
Anybody else? On this item? Seeing none, we will move on to B. public hearing to obtain citizen views and comments regarding replat 250801, a replat, a replat application to allow the applicants, Michael and Lynn McCarson, to reflect the updated ownership of a recently purchased portion of public property. The subject property is located at or about the corner of West Brown Street and 16th Street. The subject property is legally described as a replat, block 1 to 6, Kalima addition to the city of Alpine, subdivision plat on file, envelope 67, plat records of Brewster County, Texas. The record property owner is Michael Freeman McCarson and Elizabeth Lynn McCarson. The parcel identification numbers of the subject property are 10309, 10310, 10311, 10312, 10313, and 10314. The current zoning classification of the property is R2, two-family district. If the replat is approved, the zoning classification will remain R2 family district. Any public comments on that? You got 3 minutes. Anyone in the audience? Anyone online? Okay, we'll move on to C. Joe, you want to read that one?
Sure, public hearing C is public hearing to obtain citizen views and comments regarding rezone 2025-08-01. A rezone application allowing the applicant Melinda Vega to establish a commercial rental of the subject property. The subject property is located at 601 South Walker and is legally described as lots number 3, 4, and 5, block 49, Hancock Addition, south of the railroad to the city of Alpine, Brewster County, Texas, as the same appears in the plat records of Brewster County, Texas. The property owner of record is Melinda A. Vega. The property identification number of the subject property is 10842. The current zoning classification of the subject property is R4 Mobile Home District, now known as R4 Mixed Residential District, and the zoning classification will be approved. If approved, will be C0 Office Services District.
Okay, any comments? Step up to the podium, please, and state your name.
It's Martin Villarreal.
Can't hear you.
Martin Villarreal. My name is Martin Villarreal. And I have a property within 200 feet of the said location that wants rezoned. My concern is before that property used to be a bar, be the Flamingo. And I'm not sure if Mrs. Vega intends to turn it into a bar or not, but when it was a bar, our family's lived in that area for about 80 years now. And when it was a bar, we had issues with the location. We would have loitering, we'd have people drunk, throwing bottles into our property and trash, vomit, urine, and so forth. And so that our concern is that we don't want it to become a bar. If it's changed to commercial, it has the potential to become a bar. It may not be right now, but liquor sells in Alpine. So that's our concern. There's a few more comments here. Also, the tranquility of the neighborhood, the safety, the overall character of the neighborhood, we're concerned specifically worried about the commercial business selling alcohol.
Could you speak up, please? It's
Yeah,
very.
sure, sure. This on?
It's on.
Hopefully.
Okay. So, regards to the proposed rezoning could negatively affect the tranquility, safety, and overall character of the neighborhood. Specifically, we are worried about any commercial business that sells alcohol. A bar was spot zoned as a Flamingo back in the day, and it was a horrible living near the business. Drunk people would vomit in and near around the property, and all kinds of bottles and trash were thrown into our property by patrons of the business. The traffic and noise would continue beyond midnight. That has a significant impact on the neighborhood. Once a property becomes commercial, no matter if the original business does not sell alcohol, the potential exists to become one once it's rezoned. And additionally, some of us live there now, some of us plan to retire in the area and in those properties in the near future and intend to make that area our permanent home. So we have vested interest in the location. And like I said, our families lived there for about 80 years or more. We understand that the development and growth are necessary components of a thriving city. We urge the commission to carefully consider the long-term impact that rezoning could have on the residents in the area. One of the property, I own 3 lots close to that location. I might potentially want to put some houses there. So if the bar exists, that might not make the house as sellable. So that's another concern. So we respectfully request that our protests be included in the official record of the public hearing. Thank you for considering our concerns. We hope the commission will take them into account during your deliberations.
Thank you.
All right, thank you. Thank you. Anyone else? That agenda item, seeing none?
I'm just letting you know that this is Melinda Vega. I'm the owner of the Flamingo that Mr. Villarreal was talking about. So I'm just I've talked to Mr. Villarreal before by phone, and I told him that I'm not intending to making my property a bar. And so that's why I'm trying to rezone my property for C0. And that's for a business. So
C0 is Office Services District.
See, there was office
yes,
services.
office for offices and all that. Whatever C0 rezone is for, that's what I intend to do in that property. So, but there's no intent to build a bar, put a bar there or nothing like that. Like Mr. Villarreal, he never even mentioned that to me when I talked to him. His concern was the taxes going up if he made his property into a commercial property. So right next to his property was Aguilar's Pick Pack that is zoned commercial, and they always sold beer and everything there, alcohol, and there's never no problems there. And also the runways right there, which sells all kinds of alcohol as well, and there hasn't been any issues as well there. So I don't know what he's talking about urine and all that, peeing everywhere. I don't know anything about that. And so I'm just letting you know that I'm here as the owner. And so I know I'm talking to you all right now. And but I'll answer any questions that when it's time.
All right, thank you. Any other comments? Seeing none, we will move on. We need to approve the minutes of the previous board meeting.
Motion to approve.
Is motion to approve, second? Aye.
Aye.
All in favor, vote aye.
Aye.
All in favor, vote aye. Yes, minutes are approved in the last meeting. And now we move on to discussion items. We have no discussion items. We will move on to action items. Action items. A, approved variance 2025-0801, a variance application that would allow the applicants Alvaro Martinez and Elizabeth Martinez to establish a variance to the setback requirements of the subject property. The acceptable setback is typically 25 feet from a structure to the property line. This variance would allow the subject property to 0 feet of setback from the structure to the property line, which typically does not meet requirements for a residential lot under Alpine City Code. The non-conforming subject in question was established prior to the adoption of a city code and setback requirement. The subject property is located at 502 South 5th Street and is legally described as Block 1, Lots 1 through 4, Ferguson Addition of the City of Alpine, Brewster County, Texas. The property owner of record is Jacques Alberto, deceased, care of Alvaro Martinez. The property ID of the subject property is 10377. The current zoning classification of the property is R3 apartment district. If the variance is approved, the zoning classification would remain R3 apartment district. let's see,
If we
No.
can get a motion a second.
get a motion to
To approve.
to,
A motion.
in a second, we can begin discussion. Uh,
Okay, I can go ahead and start.
okay, go ahead and start.
You.
No problem. Okay, so tonight the commission with this item is tasked or asked to consider variance 2025-0801. A request submitted by Alvaro Martinez and Elizabeth Martinez. And the applicants are seeking relief from the setback requirements established under the City of Alpine Code of Ordinances. The current setback requirement for a residential lot in this zoning classification is 25 feet from the structure to the property line. So the subject property is legally non-conforming as the structure was built prior to the adoption of the city's existing code and setback standards. Due to that non-conforming status, the property owner is unable to proceed with the necessary improvements or modifications under current code requirements. Approval of the variance would allow for continued use and reasonable development of the property despite its non-conformity. Again, the zoning, the actual zoning of the property would not be affected in this circumstance. And I did provide the commission with public comments received from Kara Coates and another property owner, Karen Saluski, as well. And I did want to just preface this by saying that we definitely do take Kara's comments seriously, and we believe that there could have been some additional option, but that doesn't require the applicants to resubmit the application. Going forward, we will make sure to be more thorough as far as going out there and getting the correct measurements. But tonight, the commission can take this application and make findings as to what exactly the variance would allow. They don't have to go through the application process again. So that being said, I'd like to go ahead and hand it back to you all for any questions. And of course, Jessica Isley is here to provide more specific information.
A question for Jessica on first this. How does this play into our current ordinances, considering if you look at the lot and the space, and we've had discussions on what you can put on certain lots. Tell me your perspective on it, please.
And which one of those buildings?
So it's the,
It's
so if
the
you're
little
looking at the
brick one that's like right there.
replat survey, it's gonna be the one that's kind of sitting diagonal. It's just a little, it's actually considered an accessory dwelling unit.
It's that brick building?
Yeah.
Yeah,
Yeah,
it's not
it's a-
considered an R1 single family. It doesn't meet the square footage requirement, so it could never be sold as that. It would be considered like a casita on their property.
Right.
Okay, so I went out there twice today to measure because that was one of the things that Gio and I had discussed is that we really should have put more information, and we can put that information with recommendations to city council. They don't have to put that in a new application, so we can put in that suggestion for exactly what we're actually requesting. So a portion of the building is sitting about 11 feet from their property line, and another is about 13.5 feet from their property line. Based off of our ordinance, you have to be 25 feet from your property line.
Right, that's what I'm like.
So they're about
Yeah,
half, they meet about halfway.
Yeah.
But you also have to consider that a lot of those houses in that area, even some of the properties that are owned by the people that are not enjoying this application, they don't meet the requirements if they wanted to remodel theirs either, because a lot of those houses were built really close to the property line. And so a lot of the historical buildings in that area, you're gonna see that. Some of the older buildings on the south side sit too close to their property line. So for me, I don't necessarily have a problem with them fixing it, because right now it's an eyesore. So either they have two choices, whether they repair or demolish. Those are the only two choices that they have. From a code enforcement perspective. I know historically it probably was something that meant something to them, so, but aside from that, it's more of a code thing, so the recommendation could be for them to purchase property, city property, which they could, to the street line. And because I measured it, I have pictures showing that the measure meets to 25 feet from the property that's part of the built, like the grown, like the grass is there, it's not the street. So it is possible to do that, or to give them the variance for them to fix it up. They wouldn't be able to expand it, they wouldn't be able to add on to it, they could only actually fix the existing structure.
So that would be my next question is, do we know exactly, is that what they're trying to do, is just
They're trying to refurbish what they already exists.
refurbish?
Yeah.
as in?
remodel the inside and the exterior so that they can
Is it
preserve
gonna
the
be a
integrity of that.
storage? Is it gonna have to? have
No, it'd be
restrooms? Is it
considered
gonna
a
have-
living space, which we can't make somebody not turn it into a rental, like that's not
No,
something
you
that we
can't
can
stop that, but
regulate.
you can ask what
No.
they're gonna
It
do.
could, but it wouldn't be
Right.
considered a single family house by our ordinance, it'd be considered
Okay.
a casita or an ADU, an accessory dwelling unit, it
Okay.
would be considered.
And
It's
you
like
could,
you building one. in
and
your
you
back-
could measure 25 feet from the street.
Yeah,
to the building?
I have pictures of what I measured this afternoon.
And there's no
Um,
utilities?
I don't know if there's utilities there, they'd have to do a tap assessment. I mean, like I said, it really is up to you guys, what you guys wanna do as far as. If you want to allow the variance or not, there's a lot of things to consider.
No,
with
if there's 25 feet, why the variance?
So they could,
Cause it's from their actual property line.
Yeah.
And so they would have to.
They would have to buy city property.
Yeah,
It's
by
just
city
like
property.
over here
Gotcha.
Unless you just want to
Yeah.
factor that
on
in
Brown Street.
because of the way it was built.
Yeah.
Additionally, there is a photo in one of the public
I saw it.
comments as
Mhm,
well
yep,
of the
yep.
structure. So you can see it's an eyesore and they're wanting to improve it.
yeah,
To make it look better, but we can't issue permits if this variance isn't approved.
Yeah.
Okay, but if it was approved, you could, the permits are allowable is what you're saying.
yes, they would have a
Okay,
variance
alright,
to
that
be
was
able
my
to
question.
Yeah, that's.
update it and make it into an actual habitable space. What it was originally a habitable space,
Right.
so.
And we're not able to stop them from renting it,
No,
short-term
yeah.
rental, it would have to go through its own permit process, which would include. Notifying the property owners within 200 feet, but as far as the long-term rental, if they wanted to do that, they can do that,
And to follow up with what he's saying, I have the questions that were submitted by Ms. Coates and the question about parking, that wouldn't be applicable either because it's
Nobody
adjoining
has
that
parking
actual
there.
residence. Like it's part of that already existing single family residence. It's not considered a single family residence. It's considered a accessory dwelling unit.
So for me, what we're looking at is, it's kind of grandfathered, which the whole area is as far as like the ordinances and the being on the street but it is an older building and they're trying to refurbish it for their own purposes.
So
And it would, but if you really look at what's there, okay, I got it. Everybody
it's
else
only
is basically the
grandfathered
same.
until they touch it.
Okay,
So that's what grandfathering is. So right now, the way it is, you can board it up. Because it's been vacant for too long.
Right.
So they haven't been living,
tear
in it.
it
If they
down,
lived in
remove
it
it.
still today, based off our ordinance, if they lived in it still today. And they had a vacancy of 6 months, then they could resume it back to a living space. But it's been vacant for too long. So now it's a sitting dilapidated structure by code.
is it structurally?
They would have to have engineers. It wouldn't, you wouldn't be able to do it. So either way, either direction you
I
go.
mean, my thing is, if it's structurally sound to redo, then you look at redoing the ordinance, but if it's not, then we're just spinning our wheels here.
I think that's gonna be up to them, because how can they spend any money to look into remodeling this place if they don't have even the permits to start? So I think it's up to us, does the community wanna keep a building how it is and they can't do anything? Or we allow them to start looking at the idea, and the only thing they can do with us approving it is remodel that building and that's it. And we don't have any say-so on anything else if they rent
No,
or
and I
where
get
they
that.
are.
I'm just trying to,
It's not, and it's
It's
not,
on the
not a
timeline.
rezoning,
No, we're not
either.
rezoning, we're
But-
just saying yes.
but I can understand the concerns. I drove up there and then I had to turn around.
have to back out.
And it was interesting. It is tight quarters,
But
on
how's,
that street.
how's the city wanna go? What's the overall plan? 'Cause we had over here, remember that house bought utilities? Bought
Mhm.
right away?
Mhm.
Is that the avenue for these houses? Cause there's gonna be more that are gonna need permits eventually, right?
Yeah, I don't have an
Or-
answer for that. It's a little difficult, like a part of me kind of feels like we should have adjusted that in the zoning ordinance so that there wasn't such a big setback, especially historically on
For
the south
those-
side. Yeah, we're gonna come across it. A lot of people wanna fix those houses that are
Yeah.
there.
Yeah.
And so, and I would hate to see them removed. There was a House bill that did not pass, which I thought passed. I was gonna try to use that today, but it didn't pass.
Now-
So that protected those types of
Okay.
buildings. And it didn't
Historical
pass, so we
and
can't
things of that
use
nature,
that as
right.
a way of
Okay.
protecting it. Right now, we have to go off of what the ordinance says. Variances are only used for specific reasons. And so if it's gonna be a detriment or a cost to them that's exceeding, then you could offer that. But if it's not, and they could demolish it and build something new, that's also what we would be encouraging based off our ordinances, for them to either board it up until they're ready to remove it, or remove it and build further back on their property at 25 feet.
Yeah, I just
mean-
would hate to board more up.
Now,
So it's really up to you guys on
a-
it.
a zero setback
It
means
just-
basically
it
right up to the street, right?
Yes, that was, we put it in the packet wrong, but we can edit it and amend it. If you guys want to improve it and send it forward, we would edit it based off of the exact setback.
The
Thir-
11 to
13.
13.
Yeah,
11 or
the
13
exact
feet.
setback, and then allow them to have that front setback. The side setback is fine between the south property and theirs. It only needs to be 5 feet. They have plenty of time. They have plenty of space in every other direction. It's just that sitting on the roadside is the problem.
So
And
I,
if you look at the survey, the house is not sitting back 25 feet either.
yeah,
Yeah.
it looks pretty
Yeah,
similar, so
close, yeah.
I guess that's the thing is, we're gonna have this issue, this is setting the precedence for.
Yeah.
Whatever goes
forward.
forward, exactly.
So, I mean, and how often
Where
are
did you
people
see-
not gonna be able to buy the right of way? I bet it's gonna happen quite a bit
Yeah.
with utilities and
So why the request for zero setback instead of
it was a
13
typo.
Yeah, we'll fix it. We'll
Oh.
fix it to 11
Oh.
and 13.
or
and a
11
half.
and 13?
That's just a typo.
Yeah, the zero to me is like, what are you?
Yeah.
I know, that was.
That means it's right on the street, like it'd be like a commercial building where it's like right on the.
Yeah, there wouldn't even be any place to walk,
You wouldn't want that.
but,
What about this concept of the whole area being,
you talking to Jessica?
I don't know, what I'm talking.
Okay, go ahead.
I'm just talking. But the concept of the whole area, on the South Walker Street, being,
No,
the
this isn't
master
Walker
plan
Street, this
in
is
in
Fifth
view
Street.
of, that could be coming, commercial anyway.
This is Fifth Street.
We're
No,
talking.
it's not- no, no,
Fifth-
that's- no, we're not there.
We're
Where
eight.
are we at?
We're on Fifth Street.
What's our time? So,
We moved on. That was the last,
Yeah.
but we'll be back to Walker in a couple.
Yes.
Yeah, we're coming back to Walker. So I should, yeah, I was looking at the map, your map wrong. But no, we're, like, if you go past the cathedral and head straight up up that hill.
It kind of dead.
And it dead ends right there.
It's like
There's
a
kinda-
cul-de-sac.
Oh,
Couple little
Show
bars.
us the. house.
oh,
right
so
there.
we're Back there again.
So we're there.
So I know where I worked, PCHS had a property like that it was not in the sign back, and it was in Marfa. And it took us forever to get approval just to fix that building.
I know.
And so I do think we're gonna set precedency, but do we want these people that own these buildings fixing them or not? That's just.
To me, it kind of brings back discussions we've had in the past of trying to make more affordable housing smaller. You know what I'm talking about, Jessica, the
In this case, that
the
was,
little homes
yeah.
and things like that. And this is one that was there. It just needs to be redone. It's about the same. How many square foot is that place?
It's not a house, it's considered a
But
neighborhood.
I know, but
Yeah,
I'm calling it
it's very small.
it wouldn't meet the
Like-
requirements for,
is it under
because-
900 square feet?
It's even-
oh, yeah.
Yeah, it wouldn't even matter anyways, because it's.
No, I'm
an
just
accessory
thinking that
dwelling.
that's
Oh.
kind of what it reminds me of because we're
Oh.
trying to encourage more of that in the area.
Yeah, but on larger pieces of land.
Well, this piece
For
of
the tiny-
land is
for the
large.
tiny
It's not a
homes.
whole lot for itself.
At the time.
Yeah.
Instead of-
It's all platted together with the main house.
It's all one, yeah, so it can't be it couldn't be a tiny home, it's already part of a home,
No, it's fine,
Um,
Bill. It's freestanding.
so
It's
it is
freestanding.
freestanding though, yeah, but.
But I know
yeah.
what you're saying, we're encouraging more tiny homes, so that's what you're saying, this kind of gives you that view. I mean, it looks beautiful, if they would fix it, it would be nice, see more things fixed in the community.
Right, we've got, of course, the neighbors' concerns too, with not being enough room to maneuver around there. But let's ask Elizabeth, some questions here. What are your all's plans for this piece of property? Ms. Martinez,
You need to turn your volume on.
Ms. Martinez, can you hear
There you
me?
go.
Can you hear me?
Yes, we can hear you now, yes.
Okay, all right. So the property is actually 4 lots. So there's plenty of parking on the property and not even on the street. So to me, that's a non-issue. Whenever we go over there, we park in the property, not necessarily on the street. But if you think about it, I mean, if there are other It's got 4 lots, so I could put 2 other buildings on there. And I've been told that before, since it is zoned commercial. But, or 2 other houses or whatever, 1 per lot.
This is
But
not zone
that's
commercial.
not-
This is not zone commercial. This is, your property is
Well-
not, commercial.
Well, it's zoned apartment, right?
It is
No.
zone R3.
Which
Apartment district.
means,
Apartment district is not commercial.
okay, which means what? What exactly is apartment district?
Houses, people could live there, but you cannot have a business there.
Right. Oh, okay, well,
Yeah.
okay. Even if they're rentals, you couldn't do that?
No,
R
Wait, go away.
R3s apartments,
Long-term rental.
could be long-term rentals.
Okay,
It can't be short-term rentals.
okay. Well, I wasn't planning to do a short-term rental. Like I said, and like I put on my application, I planned to use that for our family, which we do go over there fairly often if there's, festivals and whatever, but this would allow us to go whenever we wanted to. We're only a couple of hours away, 2.5 hours away, and we would have somewhere to stay and not pay, $150, $180 a night. So, but the parking to me was a non-issue because there is plenty of parking on the property. Was that your question about the parking?
not for me.
Not-
We
not
wanna
with-
know
not with-
what
not
your
with-
question about parking, your personal plans are, and what I'm picking up on you're saying is that you want to renovate it so you'll have your own kind of place to stay when you come in
Correct.
the area, similar to just like what you were saying earlier, a
A
casita.
weekend
or something like
getaway,
that.
yeah, weekend getaway or getaway for a week or whatever. Yes, exactly. Exactly. And that's what I put on, that's exactly what I put on the application.
And can you address your neighbor's concerns?
What specifically?
Well, there was various letters that came in on that. But you have some of your neighbors right now, right there with you. They were concerned about traffic.
Okay. But,
They-
but
they were-
what traffic exactly? I mean, if it's just myself, my husband, it's a small house. It's not like we can have, big party or anything there like that. I mean, I'm not exactly sure where the concern for lots of traffic would be. Whenever I've had work done there and I use one of your contractors, they go and park for the day. Is that what you're talking about? Parking for the day and to get this thing renovated? It's not like
Oh.
it's gonna have a lot of parking, a lot of people parking around there or
Right.
traffic up and down or anything like that. I don't see that. I've remodeled a lot of houses and that's never been an issue. Even with the small ones, I have 2 other very small ones under 900 feet, under 800 feet that I've redone. And there's never been, just a bunch of traffic going through or anything like that at one time. It's
Well,
usually
it's-
one contractor working at a time.
Yeah, there is no through road there, is there? So,
No.
No, I think it dead ends up on the mountain, up the hill a little bit. Yeah, it dead ends up the hill a little bit.
Where you trying to turn?
By
it?
improving
Yeah.
the property, that small building, I would think it would improve the value of the neighborhood too.
I would too.
It
I would
also
think
has
so
room
too.
to build 25 feet back on that property.
Yeah, and maybe you want to address putting your parking behind the building if your neighbors are having the issue with you parking on the street.
But if you go and look, there's parking beside the building. There's
I'm
plenty
not-
of parking, yeah,
I'm just
right
throwing out-
beside
No.
it.
We're
Yeah.
trying to address your neighbor's concerns, not what their situation was. They had a problem with potentially parking. They had a potential problem with probably the construction itself. I'm not sure. So we're trying to address those right now.
Okay, well, that's what I'm asking, what specifically, so I can answer
I
your.
think probably what I heard from your neighbors is, and you could address this with them, regardless of what we do, would be how you could add additional parking that wouldn't interfere with what they have going on in the neighborhood. And that to me,
Oh.
you're saying you have you've already said you have the lots and you have the ability to do that.
Yeah,
then
there would
I
not
think
be, I'm not sure why parking on my own property would be an issue for the neighbors.
I'm just saying that's what they're saying and that's what we're throwing out there, so.
Yeah, that's my point exactly. I don't understand where the issue with parking
Okay.
is if I'm parking on the actual property, not in the street, on the property. There's
Okay.
plenty of parking between the two structures that are there now.
Another concern was the 0-foot setback, but we've addressed that.
Right, right.
A third concern was the verbal description that you gave in your application does not fully reflect the proposed improvements. But I'm not sure what
I'm not sure what that means.
they were talking about there, but here's one they addressed. You allowed tenants to accumulate junk and property, and it is an eyesore. You fail to secure the building against use by trespassers.
Nothing to do with
Has
the
nothing to do
setback.
with it.
You know, if I'm not there from one day to the next or whatever, and the building is vacant, I would think that once it is fixed up, remodeled, everything is secure. Wouldn't that be a good thing?
Okay,
Yes.
thank you, Elizabeth. We appreciate you. Thank you.
So.
Thank
that's
you.
The request for the setback variance. Just keep in mind that this property has a building sitting there that doesn't meet the requirements. And you can pass this variance the way that it is, or their end result would be that they would have to board it up, demolish it, and then build something 25 feet back to meet their requirements. Yes, we are gonna have other buildings that come up that historically cannot move back, but they do have plenty of land to do that. So that's up to you guys to make that decision if you're gonna grant the variance or not.
And-
Or suggest it. should I say.
Would they have to resubmit to change it to 11 to 13 feet?
We would amend it in the.
They just amend it?
Correct.
We need to vote on it.
Any further comments?
I would recommend actually, offering an amendment to the original motion and then putting in or basically to allow us to provide that specific setback.
Okay, well, I'll vote to offer the amendment, but
Okay.
Any seconds?
oh,
Okay, we would like to see the amendment. And added to this. Now, are you ready to vote? On the,
Gio, do you
Action
want to
item?
do anything else to that?
So first, if y'all can go ahead and vote on that amendment first.
okay. Ready to vote?
Aye for
All
the
aye in
amendment.
favor, it
Okay,
is unanimous.
And if y'all could, just vote on the original motion as amended, which is just accepting it as the.
Accept the amendment.
I vote to
Aye.
the original as.
Aye.
Okay, perfect.
Unanimous.
That's approved. Perfect, thank you.
All right. We're gonna move on to section B. Approve replat 2025-0801, a replat application to allow the applicants, Michael and Lynn McCarson, to reflect the updated ownership of a recently purchased portion of public property. The subject property is located on or about the corner of West Brown and 16th. Subject property is legally described as a replat of block 1 through 6, Kalima addition to the city of Alpine. Subdivision plat on envelope 67, plat record of Brewster County, Texas. The record property owner is Michael Freeman McCarson and Elizabeth Lynn McCarson. The parcel identification number of the subject property are 10309, 103-110, 10311, 10312, 10313, and 10314. The current zoning classification of the property is R2, two-family district. If the replat is approved, the zoning classification will remain R2, family district, two-family district. Do we have a motion?
Second.
Have a second? Okay, we can begin discussions.
What are they replatting this to do?
Well, I have some questions on that because I think,
Do you know, just?
that was a lot of things. We're not
Go
sure.
ahead.
Go ahead and start, yeah, so.
Thank you.
Alrighty, so tonight, the Planning and Zoning Commission is asked to consider replat 2025-0801, a replat application submitted by Michael Freeman McCarson and Elizabeth Lynn McCarson for the property located near the intersection of West Brown and 16th Street. This replat is being presented in fulfillment of a condition required by the city as part of the terms of sale of an unimproved public rights of way previously located within the Kalima addition. The sale was authorized through the adoption of ordinance 2025-04-04, which vacated and conveyed portions of Saltillo Avenue, Monterey Avenue, Toluco Avenue, and Morelos Avenue to the applicants following several months of council review and revision. So essentially, the purpose of this replat is to update the public record to accurately reflect the current configuration and ownership of the affected parcels following the approved conveyance of the applicants purchasing those parcels from the city.
And none of those streets are actually there.
No, they were unimproved city streets, but we still owned them and they were still technically streets. Now they are no longer, most of them are no longer. We did retain one for ingress and egress purposes. And that was Avenue C, but the remaining portion of those streets they were sold to the property owner.
Okay.
But those are in these lots now, before we could see them, right?
That is.
Okay, and then you left the easement.
So, and this is actually an accurate survey included on page 31 and 40. All of those, there used to be streets in all of that property. And the only one that we retained is Avenue C and Olive Street behind the properties. There was more, there was about 4 more.
So these are already sold, we're just doing the last step of getting the replat.
Yes, this is just to make sure the public record is up to date.
And is this a new owner? Because we've talked about this area before.
Well, originally the applicant did submit a replat. It didn't make it to planning and zoning because of the public property that we saw on the survey. So they went through a whole application process on the council side and the council sold the property.
Okay.
So I don't believe they've ever made it through the planning and zoning commission yet.
So does this,
The owners remain the same.
The
The
owner,
owner remains
yes,
the
the
same.
owner does remain the same as previous. It's just that now they own all the portions that were previously city properties.
how does this affect the surrounding neighbors?
It really doesn't. So when it comes to a replat, because it meets all of the minimum requirements, it's really more of a formality and the city doesn't have discretion to disapprove of it. It's not like rezoning where the city has full discretion to determine the zone. With replats, it already meets the minimum requirements and this is more of a formality.
Yeah, this, but there were, because I talked to people there, the people with questions, because they're my neighbors.
Yeah,
I live right on the other side of the railroad tracks. And so what their concerns were is what is gonna happen with this property?
yes, and those are valid concerns and I believe some surrounding property owners did approach the city council regarding those concerns at one point. But what happened is they came back and they heard what the property owner had to say and they just, I think they're okay with it because they never showed back up.
I
They
think we
did.
might have some people here tonight that would like to.
Well,
address
they're
that
welcome
too.
to come up, but again, replat, there's really not discretion.
Right,
in
right, right.
Disapproving of that if it meets the minimum requirements, it does, so.
Whenever we see replats, it's just,
Right.
it's formality, we just process it, because
Right.
we need it accurate. We need it,
And
Okay.
especially in this
it's
case.
too late to have to discuss if you, how the neighbors are impacted and stuff, I think, right?
Well, we can address their concerns, answer their concerns, but we it can't really change it, yeah.
And again, this is
I
a
think so.
requirement that's imposed by the city, so really, regardless, they'll be able to do what they want to do.
Mhm.
Even if they didn't do this, is we're requiring them to do it to update the public record, that's it.
Right.
Okay.
Was there anybody that wanted to express concern about this in the audience? I don't see any. Back. I'm on the wrong page. So
We wanna make a motion.
do we have a motion to approve?
I'll make a motion to approve.
I'll second.
I,
Aye.
Vote.
Aye.
Motion is approved unanimously. And now we move on to C. Approve rezone 2025-0801, a rezone application allowing the applicant Melinda Vega to establish a commercial rental at the subject property. The property, the subject property is located at 601 South Walker and is legally described as lot number 3, 4, and 5, block 49, Hancock Addition, south of the railroad to the city of Alpine, Brewster County, Texas. And the same appears on the plat record of Brewster County, Texas. Property owner of record is Melinda Vega. The property identification number of the subject property is 10842. The current zoning classification of the subject property is R4 Mobile Home District. The zoning classification, if the rezoning application is approved, will be C0 office services. Is there a motion to approve?
The motion?
Second.
Let's see a second. We can begin discussions.
I can go ahead and start off. if you
Go ahead.
Alrighty, so there's a lot of information on this one. I did provide all the information in the packet. I'll just briefly go over it now because I think it's pretty important for y'all to know. So the applicant, Melinda Vega, seeks to rezone her property from R4 mixed residential district to C0 office services district in order to operate a commercial rental, specifically an art studio. This request follows a prior unsuccessful application earlier in 2024, which sought a C1 neighborhood commercial district designation and was ultimately denied by City Council after receiving a unanimous recommendation for denial from the Planning and Zoning Commission. The commission cited concerns regarding spot zoning and inconsistency with surrounding residential uses. The property has a complex zoning history. In 2000, prior owner Alonso and Alicia Aguilar submitted a rezone request for a commercial designation. However, that request was denied by City Council following public opposition and was tabled indefinitely pending a comprehensive planning study. The city has since confirmed the property has continuously been designated as residential on all officially adopted zoning maps, including those from 1986 and 2013. While the Flamingo Bar previously operated at the locations, our records indicate that it did so in violation of applicable zoning regulations and without formal commercial designation. So regarding the updated request and legal considerations, the applicant has now modified the request to rezone to C0 Office Services District, a less intensive commercial classification than her previous C1 request. While this change demonstrates an effort to address prior concerns, the rezone still constitutes a non-contiguous spot zoning request as the property is not directly adjacent to any commercially zoned parcels. In April 2024, the Planning and Zoning Commission and City Council took action to address spot zoning through Ordinance 2024-08-01, which removed the ability for either body to initiate spot zoning requests except under narrow, legally defined exceptions. The ordinance codified a balancing test derived from the Texas Supreme Court case Barr v. Tippett, allowing spot zoning only if it clearly meets 4 criteria evaluating public purpose, surrounding land uses, suitability of current zoning, and relationship to public welfare. While the applicant contends the proposed zoning change may align with some of these factors, such as a location along a major thoroughfare and future commercial potential, no changes in surrounding conditions or long-range planning documents currently support the rezoning. Furthermore, the Planning and Zoning Commission has previously unanimously recommended denial of a substantively similar request, creating additional legal risk and procedural applications should the matter proceed. Now, as far as procedural notes, per section 803 of the Alpine Code of Ordinances, if the Planning and Zoning Commission recommends denial of the zoning application, a supermajority vote of the City Council, at least 4 out of the 5 members, is required to approve the application. This elevated threshold reflects the seriousness with which the city must weigh deviations from adopted zoning plans, particularly in cases involving spot zoning. On to the recommendation. The Planning and Zoning Commission is asked to evaluate rezone 2025-08-01 in light of the legal restrictions and exceptions outlined in Ordinance 2024-08-01, the long-standing residential designation of the subject property, the lack of direct commercial adjacency, the prior unanimous recommendation of denial and City Council rejection of the earlier C1 application, and the requirement for a supermajority council vote if the commission again recommends denial. Should the commission determine that the request satisfies the balancing test under Barr v. Tippett, findings of fact supporting that conclusion should be clearly stated to mitigate legal exposure and uphold the integrity of the zoning process. So under Texas law and is codified in Ordinance 2024-08-01, spot zoning is presumptively illegal unless it meets a 4-pronged balancing test established by Barr v. Tippett. The City of Alpine Zoning Code incorporates this test to determine whether non-contiguous zoning request or spot zone may be lawfully granted as an exception to the general prohibition. This test is not applied as a checklist, but rather through a holistic weighing of 4 factors. 1, substantial detriment or public purpose, whether the rezoning causes substantial detriment to surrounding properties or serves no substantial public purpose. 2, adverse impact on surrounding lands, whether the rezoning is substantially inconsistent with surrounding zoning or land uses. 3, suitability of current zoning, whether the property's current zoning classification renders it unsuitable, impractical, or confiscatory in light of its location, shape, or size. 4, relationship to public welfare. Whether the proposed zoning bears a substantial relationship to the public health, safety, morals, or general welfare, and whether there is a demonstrated public need for the proposed use. So, recommended procedures for applying the test. To ensure compliance with state law and minimize legal risk, the Planning and Zoning Commission should deliberate each of the 4 factors on the record, discussing whether the evidence presented supports a finding under each prong or not. Develop and vote on specific findings of fact if recommending approval of the rezoning application, clearly documenting how the request meets the legal standards for an exception to the spot zoning prohibition. And request supplemental information from the applicant if needed to evaluate suitability of the current use or the existence of public benefit. So the next item, or the last part of this last portion, is to consider comparability to prior rezones, including whether adjacent properties have been recently rezoned under similar justification. So on the suggested finding of facts, I have in the packet here on page 36 or 40, some recommendations as far as what the commission could find to back up the decision to rezone the property, if that is what y'all want to recommend. So these findings must be formally adopted by the commission and included in the minutes if a recommendation of approval is made. And if the commission recommends denial, no such findings are required. However, a clear rationale should still be documented in the record to inform the city council deliberations and preserve the transparency of the process.
Thank you.
Thank you.
Thank you.
That was a lot.
That was a lot, that was a lot.
Thank you for that, Gina.
Very nicely put together.
Absolutely.
And we will look at each one of those.
Say, Matt, what if we just went down 1 through 4 and did sort of a little vote among ourselves and see where we stand there among ourselves? If
So,
that might
Just
resolve.
just to see if we think it meets,
Which, any of the 1 through 4s.
and it has to meet all.
Yeah, it has to meet all. Do we, as a group, feel like it
Mhm.
does or does not?
What page are y'all on? I'm on page.
We're right.
36.
36, 35.
35.
It's more like a balancing test, so it
Yeah.
doesn't technically need to meet all, but it has to serve like a significant public purpose, like, yes, the benefits have to outweigh, you know.
And I don't know if I've heard what the significant public purpose is yet. for
Well, we'll
office.
talk about each one of them. Oh, and then as far as you have the requirements on what a CO is, as far as office resident.
Right.
You can't-
CO Well, CO, if, last.
And once it's a CO, can it get changed to other C?
It's easier to change it. Once it's commercial, then
Yeah,
Well, a
It's not
commercial,
easy to change?
it's not, you can't just classify commercial. Once it's CO, then there's a possibility it could move into a C2 or one of the other.
Because it is a buffer zone. So
Yeah.
it would open up
Yeah.
so,
the commercial zoning on the other sides of the property.
and it is spot zoning.
Well, you would
I
have
don't
to
know, we have
spot
to go
zone
through
it.
the 1 through
Right.
4 and make that determination, I think.
yeah, we have to
But-
spot zone it to even get to that, but then once it's a CO, it can get switched, which I
So-
think is what we were hearing.
You
But-
want me to
but-
read
Yeah.
the CO?
I would like to see what the CO, because I know one of the biggest worries is that it's a bar, but we know a CO
No,
can't
CO
be a
But it
bar.
can
Alright,
get
go
switched
there.
easier.
Okay, so CO
Yeah,
office
but they would
services.
have to come back through a group like this.
Right.
To do from
But once you
CO
get-
to C1,
Yeah.
and then at that point, we could determine.
Yeah,
Right.
they
I-
can't change it. Yeah, we
We
would have.
can't change it, we can't, so
So-
I wanna know what CO is, because I felt that that was actually made for areas that are neighborhoods, but you know, where an accountant office could go, or an
Right, let me
attorney's
read it out
office.
to you. So CO offices district, purposes of district, the office services district is designed to permit those business and professional services that serve primarily the nearby residential areas or adjacent retail and commercial establishments. So activity is characterized by a relatively low daily volume of direct customer contact. So basically, it's not a retail place. It's like a office where you might go to your insurance agent or something like that. The regulations of the district are designed to permit the allowed uses while providing protections to adjacent residential development. The district may be located appropriately either as a buffer between residential and more intensive commercial or industrial uses, or as freestanding zone placed for maximum efficiency to service surrounding residential uses. Principal permitted uses, building structures and land shall be used, buildings and structures shall be hereinafter be erected, altered, or enlarged only for the following uses: a beauty shop, dental, medical, and optical laboratories, health service facilities such as clinics, offices for dentists, doctors, and other practitioners of the healing arts licensed or similarly recognized under the laws of the state of Texas. Office, business, any office in which goods, wares, or merchandise are not commercially sold or exchanged. Office, professional, accountant, architect, engineer, lawyer, surveyor, realtor. Offices for specialists in supportive health fields such as physical, audio, and speech therapy, psychotherapy, podiatry, and psychological testing and counseling. It can also include R1, single-family district, R2, two-family district, or R3 apartment district. Studio, and this is just a caveat, for professional work or teaching of any form of commercial or fine arts, photography, music, or drama, dance. So what confuses me here is in the beginning when Ms. Vega was trying to get it, I guess, rezoned C2, and that what her original one was, they were wanting to do retail there. But that's not
Yeah, that's
the
not allowed.
case now. You couldn't, this would not fall under that. You can't do alcohol there. You can't have a liquor license. You,
Can't do any
none of
retail.
that
You can't do
would
any retail.
apply under CO.
I remember they created CO actually for us, for the clinic, because
Uh-huh.
people were very concerned. There was a neighborhood and so they created this for people that have little offices like an accountant or healthcare. That's why healthcare is so much in there. And so we're in the same boat. The clinics are. We can only use it for healthcare and that's it.
Well,
So-
it's in the first paragraph, it says it's designed to service the community.
Hmm.
Which would be, you know, again, a healthcare or somebody.
Supposed to be something also kind of low traffic or so,
Mhm.
you know, that was the big concern of people and. The only thing I have to say is that I know we've been talking a lot about going 118 with more office spaces and stuff like that. And so this is gonna be one of those, either we do or we
Well,
don't.
I think it's gonna take, my personal opinion, is if you look at that map and you look, you know, closer into town, you have some C1s and C2s on there. And it's gonna take somebody going into those properties and developing them out and start the development, but you can't just say, okay, CO, I want to put an art studio in here because that's what I want to do.
So
Just my opinion.
I'm just gonna, can I say something?
Don't
Go ahead.
do.
No, no.
The C0 is used as a buffer zone. So the reason it's considered a spot zone is because it should be touching a C1 and
Okay,
touching
thank you for that.
Touching something, see.
a residential, and it would be squished to the middle. So technically, Aguilar's is C1 and there's a vacant lot in between which this gentleman owns. And then
Then
the
they're all
lady that's
rest of
the
them are
Miss Vegas property. So technically, his property could be the C0 because it's touching commercial and it's touching residential and it's used to buffer that space in between commercial and residential. And that's what C0 is supposed to be used to. It's supposed to peter off the traffic flow from a commercial district, and that's what it's supposed to be used for. So it should be wrapped around commercial so that you have less traffic going into a residential zone. So technically, it doesn't qualify because it's not touching a commercial property.
Thank you for that.
Yeah,
I
it
think
has to be touched.
last time we left it that she was gonna try to contact or try to rent or try to.
Probably could convince the owner of that property to,
Do a land lease.
That's him right there. That's there, Martin Abadial,
We have no interest.
the owner between Aguilar's and my property.
And he wants to keep it residential.
Mhm, keep it-
So it would be considered a spot zone indefinitely.
Okay,
Matt,
at
did
this
you want to go through the 1, 2, 3, 4, just so we can?
Yeah,
resolve this?
I think we should. So as far as the weighing the four factors, one, substantial detriment or public purpose. Whether the zoning causes substantial detriment to surrounding properties, or serves no substantial public purpose. And of course, we already have evidence from one of the neighbors that this is not something that he would be happy with, to say the least.
But his was because because of a bar. That's
Yes.
why he wasn't happy with it because he's not wanting it to be a bar. That's what Mr. Villarreal just said.
Correct. Adverse impact on surrounding lands. Whether the zoning is substantially inconsistent with surrounding zoning or land uses. So let me ask you a question. On that property, there's a junkyard. Is that part of the property?
Yes, that's my property.
That's your property. How does the city classify, oh, I don't know, what do you call it besides a junkyard? What's your name? What's your description of it? Melinda?
Where I have all the cars?
No, yeah, where you have all those old cars.
I mean, they're just there. I mean, we don't, they're just there for storage.
The storage, okay.
Yes. There's no business there, nothing going on.
Does the city, is the city the one that regulated to put the fence up around that?
It meets the requirements because it has a fence, right?
I can't see it from the public right away.
Okay.
So
So
like, you know, it's covered by a fence.
by a
so-
fence, so.
I didn't know that there was, I don't know what's behind that fence. I've never
There's
looked.
a aerial in the package.
Yeah.
It's a-
Oh, there's an aerial? Is that why they're saying that? Okay.
Oh, you can look through the fence.
Um,
You can't see it very well from that one.
Yes, that would be considered a separate issue. It has nothing to do with what we're discussing.
But-
Exactly.
But you can do that on property that is
No, you can't.
described as residential.
That's their own property as long as they have a fence around
Is
it.
it allowable if you can't tell what's
If
on,
you can see it from the street side, then it'd be considered a junk vehicle.
but if. they
If you
have
can't
the
see it,
And then you'd have to get like a warrant. It's a big, long process.
okay.
That's a code enforcement thing.
So
It's been like that for over 50 years.
On two, the adverse impact on surrounding lands, whether the rezoning is substantially inconsistent with surrounding zoning or land uses. To me, that's a no, because everything around it is
Residential.
residential and R4. So,
Mhm.
okay, on to three.
Suitability.
Well, on the two, it's not necessarily everything around there is residential. Because we have my
Everything
dad,
that touches
we
your
have
prop-
Aguilars. We
No,
have,
Okay.
Ms. Vega,
You
everything
don't
that
touch
touches your
Aguilar's.
property is R4,
And
and that is what we have to look at.
I can also, I will say that I spoke to some of the property owners who previously complained in both times in 2000 and recently for the C1 application. I explained the zone, that the differences between C1 and C0. And they said, you know, that sounds way better. I don't think we're gonna, you know, go out there and oppose. So I think, you know, it is definitely more of a, how do you think, compromise? And they didn't
C0,
show-
you mean?
they showed up the last two times, in 2000 and the for the C1 application to oppose it. And they're the ones that directly across the street, I believe. So I just wanted to mention that. They did call and they said that.
That's that 2-unit house there across the street, a fairly large house, yep.
But if you're looking at two and what it clearly defines that we have to look at, everything around her property is R.
Is R,
That touches it.
Yep.
So,
Yeah, not touching any Cs. Okay, 3, suitability of current zoning, whether the property's current zoning classification renders it unsuitable, impractical, or confiscatory in light of its location, shape, or size. So that area is
it's not
currently.
unsuitable
I
for the
don't
way
think it's
it is.
unsuitable. I think it's a good commercial.
things are-
Eventually.
It looks like,
will be,
it
but
looks
not-
like a commercial building.
Right.
And without much parking, but a commercial building. So it looks like it, so I think it would meet 3.
And another thing that I'd like to mention is if you read my recommended findings of fact. Like, I think that puts all of those in kind of an acceptable view, depending on what y'all think. Did y'all have a chance to read over them?
No, I'm just looking at them.
So
Yeah.
page 36, we've got a response to each of them.
Yeah, so we'll come over to those and look at those individually in just a second. And then relationship to public welfare. Whether the proposed zoning bears a substantial relationship to public health, safety, morals, or general welfare, or whether there is a demonstrated public need for the proposed use.
And the reason I mentioned that is because it basically answers the questions if y'all decided to go that route.
Thank you.
It benefits one person. But the public,
Maybe with the, if they see,
go ahead.
oh, it's good.
If I may. I'm gonna rewind back to number one. How, what is permissible in C0 is a substantial detriment. Or not a public purpose. Or how would it not meet that one? Jill said it wouldn't meet number one, correct?
What's that?
Oh,
I think it's a good, I think the community needs more C.
Yeah, so I
Zeros.
would say. Maybe scratch the beauty shop, but everything else in there would meet number one, no?
Mhm.
It would be for public purpose. And then I also would say that it would caveat for number 4, relationship to public welfare. Every single one of those would benefit the public in some sort of way.
I think we need more of those locations, I guess, but. Are
Yeah.
we able to,
I think the application meets 1, 3, and 4.
but we would be still, it would still be
It'd
called
still be,
spot zoning?
still be
Yeah,
spot zoning.
that's-
And
So
and
can it
spot
go-
zoning, does that open the city up to potential
No,
liability?
it does not,
Well-
because we're weighing it out with the balancing test.
If you do it correctly, that's why I made it a point to do the findings of fact. So it can back up your decision, so if we were to get sued, we would have all of these findings, it would make sense to back up the spot zone.
But the city is not worried about getting sued.
Well, we are always concerned, we never wanna get sued. Yeah, but, if you do recommend approval, I have like basically a template here of reasons why you would want to approve it under the balancing test.
And it would go to council to actually approve.
But if y'all deny it, council would, be required to do a supermajority vote, 4 out of the 5 members if you recommend it. So,
Thank you.
no problem.
I know we only have one person that came and I know he thought that it was gonna be a bar, but what they're requesting is not for a bar. And I don't know if he knew that or not.
Well, he's correct.
He's right there.
That's why, because
I'm just speaking. Someone's.
yeah. But if they knew that it was not going, that they couldn't walk in there and put in a bar, would that make a
Or
difference to the rest of your family members?
Potential.
Well, in this zoning.
This way, there is no potential. No,
No.
no, you can't. No.
If you don't mind, when you make your comments, please step up.
To be aware of that, because C0 is protecting him. And it's not, they can't do any of those things. They can't come and put a gasoline station. They can't do any of those
They have to
things.
rezone to commercial.
They have to come back to us to rezone to a C1 or C2. Yeah.
To any C, yeah.
Special use permits, even if alcohol sales are not a primary or permitted use in a CO. District, a special use permit might be obtainable through the city council, allowing the sales of alcohol beverages under specific conditions. So it is,
Well, that
It can
would
happen
still
as
be a
potential.
permitting process though,
Right.
so
but it's.
if
open
that
the door
happened,
to
we would have to
potential.
notify you all, et cetera.
That way we're back here again.
I mean, you're
Yep.
correct, if you're reading the recently improved alcohol ordinance, is that what you're reading right there? Okay, then, that would be correct, it kind of would open up the door, but it would still have to go through the permitting process and for a C0.
We had to,
But that's a special permit. It's just for a temporary event, right?
No,
no,
that's
no.
like, remember the commission considered the updated alcohol ordinance and what zones would be approved for licenses? Let me take a look here.
So we added C0 to it.
It would be by special use permit if I'm not mistaken, but I can double check.
and if you want to hold to the integrity of your spot zoning, but what you mentioned earlier. If you consider, what you said CO has to have an R4 and a C1 next to it in order for it to be C2.
Right, right. So if they approve it, it would have to meet the balancing test or, they'd have to recommend it against that.
Also, something that Mrs. Vega mentioned earlier about the pickback that used to be there and was owned by previously by the owners. We did experience problems with the pickback as well. There was loitering and there was.
My dad had,
That was thrown in front of our properties, trash.
And what was it at that time?
It used to be a gas station / alcohol. They would pick up-
Oh, that little 7-Eleven thing? Yeah.
that was Aguilar's Pick Pack, and my dad had that store for over 50 years.
Right, but you brought. it
And
up.
he never complained to the city or nothing that I've known.
Yes, you did.
of.
City council, but there were events pertaining to that place that we had a lot of problems with.
Okay, so I'm just taking a look right here for
The special
the
permits.
new alcohol ordinance that passed. Because we recently just approved a copy, so I'm not sure if you're looking at the correct one. Oh. Let's see. So it would actually call, he's not looking at our ordinance, so I'm just gonna quickly review that really quick.
Okay.
The Texas Alcoholic Beverage Commission regulations.
Oh, the TABC, yeah, so. Yeah,
But let's see what we approved, because I don't remember being in CO, but I'm like.
It wasn't in CO, it was only
No.
for C1 or was it, and then.
It was only a select amount.
Yes.
I mean, as far as you had to already be zoned to do that.
I don't think
And
C0 allows alcohol, is that for alcohol at all?
C0 never was in there.
We'll
Hunt at
Gio's
all, but-
pulling up right now, so.
Yes, it was for the convenience stores. They didn't have to come through us for the boards.
Or if you were already in a property that was concerned, then they could come and talk to them and get their
Yes.
licensing. We didn't have to go through the approval on every one of those if they were already there.
But in other communities, CO are allowed, so we need to make sure what
Oh.
ours says, because that's the main concern they have is alcohol or.
I don't
Well,
see it
so
anywhere on
It
ours.
actually really doesn't say anything about C0 in our ordinance.
Nope.
It does say. The
Property
sale of
owner.
alcohol in residential areas, the attorney had us amend it to. It basically saying absent specific approval in the zoning code, the sale of alcohol. In any residential area is not authorized unless approved by the special use permit process. So we weren't even able to explicitly deny it in, for residential areas. We're been planning to go and make an update in the zoning, to basically not allow it that way in residential zones. But regardless, it really doesn't have any explicit instructions on that, but if it was going to be approved, it would still have to be the special use permit process definitely. Like it wouldn't be automatically approved.
Would have to go before P and Z again,
Yes.
or the city council both?
Yeah.
Okay.
And let me just, can I just state this, that, cause like where Mr. Badial's property is, there's no structure there, it's just land. He has like no house, no structure, no nothing. It's just a piece of land. So
Yeah,
I don't
yeah.
know, you know, how he's saying that it's disturbance and all this, cause he doesn't even live there. It's just a piece of land.
Yeah, we're addressing your property right now.
I know.
Yes, yes, please.
So, my name is Lucia Escobedo and I live in Ward 4. And, I did go and I talked to people specifically that live behind and in front and on the side of where the Flamingo is right now. And actually a little bit further, I went in front of Aguilar's Pick Pack and around there, and I've asked people what their thoughts were if she changed the property. They didn't have a problem. In fact, they're not here because they don't have a problem. I remember telling her, hey, this is where I'm at. I sent her pictures of where there is other commercial properties around there. Regardless, that whole highway will eventually change here very quickly. If we want the Flamingo to be successful, just like any other business, then we need to make that happen. you know, that's what we're here for, is to bring business, because right now I know of other businesses that are closing. And that's not good for Alpine. That's all.
Thank you.
Thank you.
Thank you.
If I may caveat off this, with it being talked about whenever we eventually spend the tens of thousands of dollars and the years of time it's gonna take to come up with a comprehensive plan because of that being a main thoroughfare, it's always been something that's gonna be looked at as turning it into commercial. And so when I was talking to Ms. Vega about this, none of the rest of the commercial zones that I think, you know, in my personal opinion, you'll formulate chill zones would meet the Supreme Court's balancing test whatsoever at all, other than C0. Because it does benefit the public in some sort of way, no matter what they end up doing, out of what is permissible in that zoning. And so what I was thinking, you know, since it will eventually become in our comprehensive plan to allow commercial in there. But because it's such a heavy or such a dense residential area, I'm thinking the best way to go about it would be C0 on that thoroughfare, buffering that thoroughfare from our dense residential area, so it doesn't go into it any further. And then, yes, they could apply for C1 or C2, but is that gonna meet this? I don't think so. And I mean, I got almost 3 years and 3 more months of being on council, you know, unless I rerun. And so, you know, at least in that foreseeable future, I won't be in favor of that, but I am in favor of C0. But that's just me, because of the fact that it's gonna buffer that thoroughfare from that residential area.
So if we approve it, it'll just go to your team to actually approve, to make them.
But yeah, we're
Based off
all we
the
do is
overall
recommendation, all we hand out is a recommendation anyways.
And this is just my opinion. I don't know where any of the rest of my council members stand with it.
I mean, essentially, I think we all think that, like
Eventually
how
it's gonna
Rob has
happen.
said, that going south 118, it's eventually gonna grow into a commercial district. Obviously, we have to do our comprehensive plan and have that overlay, and then these won't even be considered spot zones anymore. They'd just be based off of our future growth of Alpine, and we can make these decisions a lot better. But making this decision today, because it is considered a spot zone, being able to have that balancing decision to say, hey, in good faith, we can do this, and we're not gonna get sued for doing it. Like, we don't wanna make a decision based off of. I mean, I think she's made a good compromise, because it's gonna limit still what she can do on that property, for commercial, but, I mean, eventually that whole place could be C1 going all the way down to Blue Water. I mean, it could eventually all be C1. And I think that mentally we can see that becoming more of a commercial area, but this could even essentially be the starting point of protecting the houses around that area. So,
And of course, we can't address that future right now, but as far as a C0, it meets a lot of the criteria. So that's what we're talking about here, because if you go back and you look at the criteria, the only one that you could argue that, of course, it doesn't meet is spot zoning, the 3. And I think there's a lot of reason why you want to beautify the city, why you want to have a new business in the city, or why this is good for the public. I don't think this is going to set precedents. It's going to lead the city to being sued.
I make a motion
Well,
to vote.
Okay,
Yeah.
and then, the first one was to approve, I believe, so y'all, I can just get an emotion to amend that original motion to include the findings of fact in the packet.
Yes.
Okay.
You need me to write that up for you? Or are you gonna
No,
write that?
I
Okay.
can do it as long as.
Okay.
I'll
and
make
then
the
you-
motion to
Okay,
approve.
perfect.
Any second? You ready to vote? Vote aye.
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 And then we'll just, approve the original motion as amended. You were no,
No?
no on the amendment?
No, yeah, I only.
Okay.
You voted
Okay.
no? No, no.
Oh,
All aye, right?
All aye? Okay, it is all aye.
And then if we can just, approve the original motion as amended, we'll take a vote on that.
I'll vote aye, as amended.
Aye, unanimous?
And you're gonna write the amendments up?
I'll write it all up in
Okay,
advance, yeah.
all right, thank you.
Okay, sounds good.
Okay.
Thank you very much.
All right, let's see. Any board member comments?
I see 118 going that way. I just don't want to be. I think we're trying to put the cart before the horse because we don't have all of the proper comprehensive plans put out yet.
Yep.
My
And that-
personally would
and that's not
wait
gonna
the
happen for a little
comprehensive
while.
plan and then go there. That's just my thinking.
I just think
That's
that's
protecting
building,
the
that's all
city.
it's been used for, right? Commercial in the past, so. I mean, how are they gonna use it for residential now?
It's been renovated to be used as a
Yeah,
residential.
I've
It
seen
was a
people
short-term
living there
rental.
already.
Yeah, it was a short-term rental for a while.
We
Not
stand-
yet, it's board
not
member
yet.
comments.
Oh,
For board member comments? so
We're just
getting-
talking
we're
about
getting
how we
comments?
felt on it.
Anybody else?
Motion to adjourn?
hi.
Aye.
We stand adjourned at 6:54.